Hello, my name is John Kim, the legal advisor to the U.S. Embassy in The Hague. I am here today with Judge George Aldrich, currently a judge on the Iran-US Claims Tribunal, which is based here in The Hague. Judge Aldrich is one of the most distinguished and accomplished international lawyers of his generation. He has devoted over 50 years of his life to public service in international law as a government attorney, a negotiator, and a founding judge of the Iran-US Claims Tribunal. He will be retiring from the tribunal effective April 1st of this year, and we thought that this would be a wonderful occasion to hear from the judge, briefly review his career and experiences, as well as get the benefit of any parting thoughts as he and his wife Rosemary prepare to return to the United States. So, welcome, Judge Aldrich.
Thank you, sir. Thank you, John. Well, it's been a long time, put it that way. I began my time in Washington, which is what I wanted. For my time in college and law school, I wanted to be in international law, and I thought the best place to do that is Washington, D.C. And I came to Washington toward the end of the Eisenhower administration, and couldn't find a job right at that time in international law, but I decided I should stay around. So I went to work as a lawyer for the Navy General Counsel, which in those days was in one of the World War II temporary buildings down by the reflecting pool. It was not a great sight, but it was fun anyway, and I learned a lot about the government, how it worked, the problems with it. And after about a year, one of the offers that I had been hoping for came through, and I went to work as a lawyer in Defense General Counsel, which had a section on international affairs. And I will never forget my first day on the job. The General Counsel took me around and introduced me to the other members of that group. I think the International Affairs section was all seven lawyers. And he showed me my office and said, "Okay, here you are, you've got the Far East." I said, "Oh, really?" But it was the beginning of a long-term work with East Asian and Pacific affairs, and it was a key to getting a lot of entree to things that I later did. And I enjoyed the job. It was a little bit scary in a way when you come in and you go to the staff meeting with your client, the Assistant Secretary of Defense, and he says, "Now here are some problems. What do we do about them?" And suddenly you're there expected to give some answers. You learn quickly to say, "Well, we'll work on that and send you a memo." But all the same, it's a little bit startling to come in and face issues that are what you've just been reading about in the newspaper up until then.
Well, Judge, I can relate to that type of experience. Could you give us a flavor of some of the types of substantive issues you worked on during your time at the Department of Defense?
Yes, there were everything, of course, from nations buying military equipment. I had to learn something about how the foreign military sales program worked and give advice on that. But far more interesting ones were the problems that arose out of the armed conflicts at the time. And in particular, when I started there, we were getting nervous about developments in Southeast Asia, developments which became much worse later on. But I did spend quite a bit of time with my clients in the department, and also working at that time with the State Department Legal Advisor's Office, the lawyers there who handled Far Eastern affairs, because we were preparing for a conference in Geneva on the problems about a little country a lot of people never have visited called Laos. And Laos was one of the first places where the communist growth was presenting us with real problems. And so I had to learn about Laos and Cambodia and Vietnam all as a group, and try to get prepared to go to Geneva and be on the delegation that was going to try to work out a neutrality of Laos in 1961, and enjoyed the preparation, got to know people in both the State and Defense Departments who were far more knowledgeable about the Far East than I was, and tried to help them about the legal problems and what it was we could hope to accomplish and what realistically you might be able to accomplish in such a conference. And I ended up going to the conference in Geneva as a defense lawyer, working with Ambassador Averell Harriman, who was the head of our delegation. That was an experience, I must say.
I can imagine.
Harriman was an extraordinary individual and had already done so much. I never forget, it's funny, but I never forget the morning we had a long telegram from the State Department of instructions for what he should say. And he, after a point, he turned to me and he said, you know, during the war, Roosevelt sent me off to negotiate with Stalin and Churchill with practically no instructions at all. Now every desk officer in the State Department wants to tell me exactly what to say. But of course, they didn't get their way. He said what he felt he should say in any event. But he was it was good to work with somebody like that because he was not only personally knowledgeable about a lot of these problems, but he was skeptical and questioned everything, and that made a lawyer very happy. He had a client who was not going to go out and make a foolish mistake without asking questions first.
So I take it you felt like you played a very useful, meaningful role in that negotiation?
I played a role. I don't know how useful it was in the end. I think I learned a lot, though.
Okay.
I learned a lot, and I got to know a lot of people involved in the negotiations. One of them was a State Department Foreign Service officer by the name of Bill Sullivan. Bill was, at that time, one of the few experts there who really knew Southeast Asia, and he had been there and he knew the leaders and even knew a little bit about some of the communist leaders in Vietnam. And that was a contact that continued through many years and later on. It's just by chance that he also happens to have been our last ambassador in Tehran, but we didn't have anything to do with Iran when I was working with him in those days.
That was for later. So after your experience in the Far East, I understand you then moved on to work at the U.S. delegation in NATO?
Yes. It was one of those things that I didn't anticipate, but a lot of those happened over the years. The assistant legal advisor for the International Law and Defense told me that he had been planning to send somebody else to NATO, but because of the individual's children's school thing, he didn't really want to go. He wanted to put it off for a couple of years. Would I be willing to go to Paris for 2 years? I thought that was a very easy question to answer. And my wife was very happy about it too. And so in 1963, I had 6 months of learning about NATO. In the end, almost none of that I learned really mattered very much because it just happened that my years at NATO were devoted almost entirely to a strange project called the Multilateral Nuclear Force, and it was a lawyer's delight. The idea, of course, was to put off the pressures for basing missiles aimed at Russia in Western Europe. And the idea was to give the European members of NATO more of a direct feeling of being involved in the nuclear deterrent by having a naval force manned by people from all the NATO countries who wanted to participate at sea with Polaris missiles on the ships. Well, as you can imagine, the legal problems of this with the flags of the ship being not of any nation, but rather of NATO, and the mixed nationality of the crews, all the way from international law problems of the status of the ships to the more mundane problems of how do you manage discipline and criminal prosecution of a mixed man crew, who's in charge and what law do you do and so forth. It was an absolute lawyer's delight.
I can imagine.
We spent about 2 years at it. The force was never, in fact, created. And I would have to say that the value of it, aside from keeping me busy and very happily working on some very unusual projects and problems
In Paris.
was that it got us through perhaps one of the more difficult times in which demands of some of our European allies were to get land-based missiles were at least held off by this. So it served, I think, in the end, a useful purpose. Whether it frightened the Russians, I'm not so sure.
Can you give us a sense of the climate or the scene in NATO then as opposed to now? Obviously, we're living in a different era. It's after the Cold War. Any thoughts on that?
Well, I don't think I can contribute much to that. Anyone who's lived through the time couldn't expect. NATO was a very busy and I would say quite a I won't say nervous, but it was active, and it was active in very, very serious ways. And you had to feel the tension that went on there at that time in a way that many other things that I worked on didn't produce. So it was the height of the Cold War.
Yeah.
We had. I remember when the administrations changed in Washington in 1961, the General Counsel of Defense, who was a very elegant gentleman from Pittsburgh, came into my office and said, "Mr. Aldrich, I'd like to introduce my successor." And he's such a formal man that I stood up immediately, put my hand out at this younger fellow behind him, smiled, looked forward and said, "Hi, I'm Cy Vance, how are you?" And a lot of things changed at that point, as you can imagine.
Yes.
And that was the atmosphere of Washington and NATO it was tense, often tense in those days.
Yes, I can imagine. Well, tell us, I know you had a role working directly with Henry Kissinger in the negotiation of the peace treaty with Vietnam, and I think that
It all came out of the work I had done on the Laos conference, because I think it's no secret that Kissinger worked in the White House as the advisor to the president. He did not want to deal very much, if at all, with the State Department until he became Secretary of State, which is a different time. And he had been convinced somehow, and I don't know how because I wasn't then involved, that he needed the knowledge and assistance of Bill Sullivan. And Bill and I had worked together in Laos, and so Bill knew that during the Laos conference I had drafted all sorts of agreements, some of which came to use, some of which didn't, that were useful if you're trying to get a ceasefire in place. And so he persuaded Kissinger that he should ask me to do some drafting and give us my ideas. And so I ended up drafting protocols, drafts parts of agreements on things like the functioning of the International Inspection Commission, the definition of the ceasefire in detail, what did it mean, what could you do, what you couldn't do, and some other commissions made up of representatives of the parties involved. So this apparently appealed to Kissinger to the point that I was asked to go along to Paris and be there as part of the negotiating group. And the fact that Bill was able to persuade him to do it was quite a remarkable thing, but it worked well. It was probably the most exciting time of anything I ever did. It was very difficult.
Yeah.
The negotiations with the North Vietnamese were anything but simple. And we worked in two ways. Kissinger would have his own meetings with Lê Đức Thọ and the Vice Foreign Minister Nguyen Co Thach of North Vietnam, and Bill and I, with some other of Henry's staff, would negotiate these, what we called protocols, on all these other subjects that I had worked out. And it took time. It was difficult. There were arguments about almost everything.
Mm-hmm.
But I think in the end, the package of agreements was probably as good as one could ever have expected to get in those circumstances. And I was quite happy that I'd made a contribution that mattered, and that I'd been able to actually get involved and work there. It was difficult to be cut off from the State Department, in the sense that I felt that I owed my job at the State Department, and I wasn't allowed to send any telegrams or any contact with them while we were doing this. That was just one of the Nixon-Kissinger specialties that hopefully we won't have to see again. But it worked out that I remember the day that we had initialed the agreements and got on the airplane flying back to Washington. Everybody was, of course, very happy, very relaxed. We got into Andrews Air Force Base about dinner time, and Dr. Kissinger said, well, he said, I know you haven't seen your family for a while. I assume you would want to go home, not to the State Department. I said, yes, I do. He said, but you realize, he said, you've got the texts here. You have to show them to the Secretary of State tomorrow because he's got to sign them in 3 days. Which was, he was quite right. I went in, and Secretary Rogers was, he was very quick. We went through them all together, and he came back with some questions afterwards, but basically he was he understood it, and he mentioned at the time, he said he was very happy that it took a couple of people from the State Department to get.
Judge, could you perhaps tell us a little bit about your experience negotiating a treaty, I believe, with the Soviet Union regarding the prevention of a nuclear war?
Yes, that was a very exciting time. It was toward the very end of the Nixon administration, and President Nixon was going off to Moscow in July of 1974, and we had the usual collection of agreements that had been negotiated over the months, ready to be concluded while he was there. And one day I got a call from Kissinger's office, one of his assistants by the name of Hal Sonnenfeld. And Hal said that they wanted me to go on the trip to Moscow. And I said, Hal, there are about 10 treaties to be signed there. They're all done. Charlie Bevins, our lawyer for the treaties, will go. You don't need me for those. And he said, well, there's something else we want you there for. And I said, well, what? And he said, well, come to the White House. So I went to the White House. He proceeded to show me a draft agreement between the Soviet Union and the United States entitled Agreement on the Prevention of Nuclear War. I said, well, this is something you want to negotiate there? He said, yes. So I read through it, and I said, well, I've got a few suggestions. Basically, it was a well-drafted agreement. I said, let me take it back and I'll give it more. He said, no, it can't. He said, it can't go to the State Department. This is something that's we want done in Moscow, and we want you there for that. So I couldn't say no. I said, okay, I'll go. And he said, but don't talk about it in the State Department. I said, well, I don't know who I talked to about it anyway, but all right. So I went to Moscow, and the way it was structured was that most of the group, Kissinger and Gromyko and so forth, they all flew down to Sochi on the Black Sea for about 3 days. And I was left with Walt Stessel, who was our either charge or ambassador at the time in Moscow, and a couple of generals from the Pentagon. And every night, about 10 o'clock at night, we would go to some office with where the Russians were there, and we would negotiate this agreement until about 2 in the morning. And then the next day, repeat the process and try to finish it. And we got it finished, and it was signed, concluded. And but it was a perfectly sensible agreement. I could never figure out why it had to be kept secret from everybody at the time, except perhaps that if it hadn't succeeded, they didn't want people to know it hadn't succeeded. But it was one of those fringe benefits of being accepted by Kissinger as somebody he could work with that got me into it. And I was very happy to have participated. It's I don't know that I should add it, the whole session there was difficult because the Russians knew they couldn't understand, but they knew that President Nixon was about to leave office. The whole thing about impeachment was not something they understood, and it was difficult to know exactly. If you ever had any private conversations, it was very difficult to know what to say. And
I can imagine.
I had the experience that the president gave his usual speech to the Soviet people on television, and I asked in our offices, actually our offices were in the Kremlin at that point, and I asked, is there a place I could go see it? And they said, yes, we've fixed up a TV in an office down the hall here, and it'll have it in English with Russian subtitles. And so I went down to watch the speech, and the only other person in that room with me watching the speech was Pat Nixon. And
It's amazing.
the speech was a good one. He did it before he could do it. At the end of it, I didn't quite know what to say to her, but I said, Mrs. Nixon, he did just as good as ever with that one. And she looked at me, smiled, and said, thank you, young man. That was that. It was...
Let me switch gears, because you've had obviously a remarkable career, and I want to get to some of the other amazing work that you've done. I was wondering I know you switched from this focus on the Far East, and I know you went into areas of humanitarian law, and you negotiated various treaties related to the laws of war. I wonder if you could give us a recap of some of that experience.
Yeah, well, I got into that not in my time in defense so much, though there we had been concerned with the protection of the status of crew members of the multilateral force under the laws of war. But I got into it at first because of the Vietnam business. That is, before I was with Henry in Paris. I went to Vietnam with a couple of other fellows from the Pentagon, civilians from the Pentagon, to inspect prisoner of war camps, that is, places we held communist prisoners. And basically they weren't bad because they were all built. I said, how did you design these plants? They said, well, they're all built on designs we had used for camps in Texas for Germans in 1944.
Oh,
Yeah.
wow.
So the camps were fine. The food, as far as I could tell, was tolerable. There was only one problem, that there was a separate facility called between the United States and South Vietnam, the Combined Military Interrogation Center, which somebody decided we should look at, and that wasn't so good. That was a place where a few prisoners who thought to have especially valuable intelligence they'd served in the line of communication or something of that sort were put, and I think kept isolated for quite a long time before they were interviewed. And that we had to say that everything out there was in conformity with the Geneva Conventions except that one.
Yeah.
And I cannot say exactly how that went down in Washington, but we got the point across in a memorandum to the Secretary of Defense. It was, but it taught me quite a bit about the Geneva Conventions and their value, and how it was so easy to make life unnecessarily difficult for prisoners by cutting off communication, by restricting them in many ways, by providing special incentives if they did things you liked. And the conventions are all designed to prevent that from happening. So it was a good experience. And then, of course, as a result of that, when we got into negotiations on the protocols in the 1970s, it was logical for me to be the head of delegation. I got a certain special satisfaction out of it, because we often, when we have conferences on legal matters, if we can bring in some law professors who are specialists in the field, we do.
Yeah.
And so at that conference, I could have as my assistant the man who had been my professor of law at Harvard, Richard Baxter. It gave us special cachet to the whole thing to be there with Dick Baxter and to work on those protocols. And I think we did a good job. In the end, they ran into some objections in Washington because of the provisions on treatment of people who were with national liberation fronts and that sort of thing. But there's a limit to what you could do about
Sure,
that.
of course. Judge, just backing up, maybe you could describe the protocols that you were talking about and what they generally related to.
Well, the Geneva Conventions of 1949 were well done and complete at the time, based upon the Second World War's experience and on their predecessors from the 1920s. But they didn't really deal effectively with what we might call guerrilla warfare. The conventions had been based upon the principle that every combatant, soldier for the service, should wear a uniform and be involved in the strictly straight military sense. And even in the Second World War, there had been exceptions to this that were important, but they largely had been ignored in the 49 conventions. But it became impossible to ignore them, not just because of the pressure of countries that like France, that had to deal with wars of national liberation in colonies, but also in general, for public opinion became a little more willing to say that not everybody who's fighting as a resistance fighter is necessarily a criminal.
Yeah.
And maybe you should be a little bit more liberal in protecting such people once they're prisoners. So it was partly that we worked on. I think the protocols have largely been accepted as part of customary international law now, with the questions about the War of National Liberation, which is something it was so much tied to the end of the colonial era that it may be disappearing.
Yeah.
Today, what we have isn't really dealt with by those protocols, which is the war on terror. And I was fascinated to read in the paper just the other day that the Attorney General was being questioned about what's the legal status for targeting an American in a place like Yemen, who we think have reason to believe is an Al-Qaeda operative. That kind of question didn't come up in the time in the 70s when we were doing this, and so I was happy I didn't have to give any opinion on that one.
Right. Well, I know that in addition to the laws of war, you also played a major role in shaping, I think, what I consider to be one of the most significant treaties of the 20th century, namely the Law of the Sea Convention. And if you could share with us your experiences on the negotiation of that treaty.
Well, John, I have to disappoint you a little there because the Law of the Sea, I got into it rather late.
Ah, okay.
And Elliot Richardson, who was the head of our delegation, an extraordinary individual, a great lawyer, had pretty much not only controlled the nature of what we were doing, but had picked the people. And we had a lot of experts who dealt with various areas. From my perspective, when I went into it, I went in as his deputy, and in particular was tagged to do negotiation on something that I thought was basically hopeless.
Oh.
And that was the deep seabed mining.
Mm-hmm.
Now, the idea of getting out and mining minerals from the deep seabed was one of those entrancing ideas that came along long before it would become feasible.
Yeah.
And it's difficult, if not impossible, to negotiate reasonably about something that many of the other countries in the conference thought was going to be an economic bonanza somewhere down the road, which should benefit them even if they were not major naval powers.
Right.
And particularly if they were poor developing countries, they should get a special benefit out of the deep seabed. So it was like trying to negotiate an agreement with somebody who expected to get great profits out of it somewhere way down the road somehow.
Mm-hmm.
And on my side, I was looking at it as somebody who tended to doubt that it was in my lifetime going to work at all. So I can't say that I enjoyed particularly that. I enjoyed working with Elliot. I enjoyed meeting a lot of people in the process.
Right.
But I didn't feel that I was able to make a real contribution to the development of the law. That was, other people were doing that much more than I was.
Yeah.
I did have one very happy moment in it, which I have to tell you about, and that was at the conference, the head of the Vietnamese delegation, it still in those days was from the North Vietnam, Win Co Tac had been one of our principal people we dealt with during the negotiations of Vietnam. And one day as I was walking out at the end of a plenary session at the conference on the Law of the Sea, I heard somebody calling me. I turned around and it was Tac. And he walked out with me, he put his arm around my shoulder, he said, actually, he said, you know, I've seen, how is Dr. Kissinger? You know, I saw some TV, and he's looking tired, you know, and he's putting on weight. You know, he's got to watch that. He said. And we walked out, staring at us as we walked out with his arm around my shoulder was the Soviet ambassador who couldn't figure out what in the devil was going on here. But that I remember a lot more than I do most of the development of the protocols, but I did in the end have some testimony before the Senate on the protocols, and I think we did a good thing in the development. I just don't feel that I really had a great deal to do with it.
Well, I'm sure you had more to do with it than you're giving yourself credit for, Judge.
Well, I may not remember. That's one of the things about working until you're 80. You can plead, you forget things too.
All right. Well, I want to turn now to your appointment to the Iran-US Claims Tribunal, which was established in 1982, and it's obviously been around for now over 30 years. You're the founding member of that tribunal. If you could tell us how it was that you came to be appointed to the Iran-US Claims Tribunal and what it was like in those early days at the tribunal.
Yes, well, how it was that I came to be appointed, I can tell you what I know,
Okay.
which is only part of the story. One day I had a call from the acting legal advisor. It was, of course, early in the Reagan administration, which had taken over this agreement that was done at the very end of the Carter administration. And I had already learned that my pro forma resignation as head of the Law of the Sea delegation, acting head of the Law of the Sea delegation, had been accepted by President Reagan. So I was sitting there wondering what I was going to do. I was still technically employed, I just didn't have a position in the State Department. And I had two boys in college, and so it was getting a little nervous. And I got a phone call one day and said, well, you know, this tribunal we're going to create under the agreement that freed the hostages, it requires us to have 3 members of the arbitral tribunal in The Hague. And we have found 3, but one of them is pulling out. He doesn't want to be there because he's a judge on the U.S. Court of Appeals, and this wouldn't work for him. Would you be interested? And I was on the telephone, and I said, well, Mark, you know, I don't know. I hated that whole hostage crisis, and do I really want to go and work with Iranians? I don't know, but you know, I've got 2 boys in college. What does it pay?
For the benefit of our audience, Judge, could you perhaps briefly discuss the types of cases that came before the tribunal, and then how that nature of that work has changed and where it stands now?
Okay, well that'll take a few minutes. What we didn't really know when the tribunal was established how many cases we were going to have. There was a period for filing. And we were thinking in terms of filing of claims mostly by private American individuals or companies that had been doing business in Iran or had been there and had claims because of the revolution and being thrown out or the property expropriated, contracts broken. And we thought maybe there'd be several hundred of those. Well, there turned out to be well over 1,000 of those claims. There were also a lot of smaller claims, which eventually were taken up and settled as a package. But when we realized how many there were, we knew we were going to be there for quite a while. But, and of course, in addition to that, the claim settlement declaration provided for the 2 governments to have claims against each other and for them to be able to argue violations of the agreement itself. Yes. And we had not foreseen, I think, at the outset that we were likely to have a number of those, but we have. So the tribunal turned, as soon as it could get itself properly organized and work on developing a staff, to set up the proceeding for claimants to file. And we put our emphasis on the private American claims. And each of those had their own law firm, and therefore they could move fairly quickly. Even so, it surprised me how long it took to get cases ready for hearing. It was really about 2 years before we got many cases, claims to be ready to hear. We went through the briefing and the evidence, and I guess not having been involved in any way in domestic litigation in the United States, I was surprised at the extent to which documentary evidence could come in and flood you. Mm. And I had to learn that here. But so we really started hearing these American claims, I think, about 1983. And we were completely busy with them. To get the work done more efficiently, we divided into chambers of 3, 1 American, 1 Iranian, and 1 third country person, so that we could have 3 cases going at the same time, not just in one. And it worked well. We ended up, when we finally finished all of those claims, we paid out not too far short of $3 billion of Iran's money to American claimants, when it was all paid. Right. And it worked pretty well. Iran had a few claims, Iranian entities did, but they were very slow to move some of them. And one of the things that we're still left with is some claims of the Iranian government that were based on, among other things, the Shah's purchase of military equipment from the Pentagon way back in the 70s. And they've been very slow to get this working. It's very complicated, very probably very difficult to do. I suspect that some of the people in Iran who had worked on these things in their military either had fled the country or were no longer people that the government would trust to deal with them. And so they may not have had all of the people at hand to move these cases as fast as they thought. In addition to that, we have, as you know, John, we have these disputes that come up between the two governments about is something consistent or inconsistent with the agreement.
Right.
And those take time, and they cut into deciding the other claims.
Right.
So that, those we deal with in the full tribunal of 9, which takes horrendously long time to get decisions out. So that the whole process took far longer than any of us anticipated at the beginning.
Right.
But I think if you look at what was actually involved and how many cases there were, how we could have handled it, I don't think it could have been done a lot sooner.
Right.
It's once we reached the point, though, where basically all of the American claims, or almost all of them, were done, we're sitting there, and to some extent we are really sitting there waiting for Iran to get some of its things ready for us to take up.
Right.
And that makes it more difficult for the morale of the tribunal and the staff, but we have to keep it together and deal with those things. It would be quite wrong to walk away from the process because they were slow about some of these things. So
Right.
we've done it.
Well, the Iran-US Claims Tribunal has always struck me as kind of a bit of an oasis of the rule of law between these two governments, the US and Iran. I'd be curious as to what your thoughts are on the overall impact or that the tribunal has had in terms of international law, global politics, diplomacy, more generally.
Well, I think the tribunal has greatly expanded the number of judicial decisions available on things like breach of contract by a government, expropriation of property by a government,
Yeah.
and compensation for these things. I think when we started, there was perhaps a greater dispute about what was appropriate compensation for the person or company whose property was expropriated by a government.
Yes.
And I hope that our precedents will say the compensation required is the value of the property that was taken, and that's where we came out.
Right.
And that's what was paid by Iran as a result. And I think it's right. So I think in that respect, the tribunal's jurisprudence is something that will be cited down through the years and
Yes.
has effectively, if not changed the law, it's clarified what the law is.
Right. Right. Would you have any advice you would offer to the U.S. government in terms of lessons learned from the tribunal, or things that you might do differently had you do it over again?
Well, no, I don't think I would say anything to them about how to do it differently. What I would say to them is this, that the tribunal's lasting effect has to be an effect of the respect for law, the respect for the requirements of international law in dealing with other governments and with individuals and with companies. And what I would point to the case I referred to in which Iran is claiming for Shah's purchase of military equipment. This is a case, of course, that goes back to the 1970s. It's unimaginably large and difficult to deal with, as one can see. But it's true that when you have this kind of a case, the necessity to decide it, it's going to take a long time, it's going to take a lot of trouble. It's a case that should be settled between the two governments. It should never be heard by our tribunal. If we hear it, it will take years. Years, this long after the claims arose in the late 70s. And it's far better to settle it. Somebody asked me the other day what I thought was the place of the tribunal in the history of, or at least say the history of the last 100 years in dispute settlement. And I said to them, well, I think it's very hard to say because we're not quite finished.
Right.
What we've done, I think, is very useful and will last. But right now, we need these two governments to negotiate a settlement of the remaining thing because it's so complex and so it would take so long. And besides which, I think they need it. I don't think that you can. I don't suggest that I believe you will find it easy to settle it on its own. Nothing will be easy in such a negotiation. But if you could make that negotiation part of a broader negotiation restoring some kind of reasonable relation between Iran and the United States, which would have to include the nuclear problems that we've heard so much about, then I think the work of the tribunal could properly go down and take its place as a very significant contribution in the history of dispute settlement. So if there's anything I can do to encourage the two governments to use this opportunity of the remaining negotiations at the tribunal to bring them into a broader negotiation to resolve disputes between the two governments, then I would feel that my nearly 31 years here have indeed been well spent. The people I've worked with have by and large been extraordinarily interesting and challenging, and it's gotten me to meet and work with people that I otherwise never would have, whether it's Elliot and I were meeting Gromyko at one point, and I've had indirectly, at least, some dealings with several presidents of the United States, which is not something that I would have anticipated even coming to Washington.
Exactly.
I have to say, I think my whole approach was conditioned by the time I grew up. I mean, I grew up during the Second World War and right after it, when the United Nations was being created and all kinds of international law developments were going on.
Right.
And I said, that's what I want to do.
Right.
Even though my father, who was a businessman, wasn't too excited about it. He said, international law? Well, estates and wills are where the money is. But,
Yeah.
so I didn't go for the money, but I had a great time with it. Basically, what our country has seen in the last 40 years has made it clear that international law and development of international institutions has got to be one of our biggest concerns and focus of our attention in the next half century.